Welcome to Jurisprudence. Lesson 23 is focusing on the legal realism versus legal positivism. Already we have talked widely about the legal positivism, how the positivists were stuck with the ideas of the objectivity of law and its application, and the positivists arguing that law must be applied as it is, also believes that the judges reading from the same script, referring to the same laws, making reference to the same precedents, and also having the same facts, and listening, hearing from both parties, and getting the arguments from both parties, must come up with the same decision or the same determination. Realist school of thought that emerged in the United States of America alongside the legal positivism seems to see it differently, that same laws, same crimes, and same facts and same evidence, the judges seem to make different rulings. And what really defines this? How do we come up with different rulings by different judges on the same cases, the same matters, the same laws applied within the same jurisdiction? This is the starting point as a prominent question that will define the development and the emergence of the legal realists as part and parcel of the practical jurisprudence of which we are so much interested. Under our section 23.1, looking at the definition of law, the definition of justice and rights, we see that this type of jurisprudence is bringing us into the contextualization, how to contextualize the law and the practice. The judicial practice and the legal practice must fit in well within the context. That application of law to the real situation is what defines the realist school of jurisprudence that actually has been attributed to the immense work of Justice Oliver Wendell Holmes, Jr. of the United States of America back in the early 20th century, in which Justice Holmes, in his experience, first as a military serviceman during the civil rights movement in the United States of America, and after having decided to join the law school of Harvard University and becoming a professor of law and a writer, and one of the persons that have made a lot of contribution to the development of the legal positivism from the American perspective. Talking about the reality of law in this manner puts us closer to the understanding of the Anglo-American common law. That is the development within the common law as a practice and as a tradition in which law is seen more in the activities of the court, the activities of the advocates, the practicing lawyers, as well as the activities of the honorable judges and magistrates. The work done by the court is what defines to us what the law is in reality, because the law must apply itself to the reality according to the realist school of thought, as opposed to the law being applied to the situation that is already engineered by the legal positivism, the legal formalism, the law as it is in writing, as it is in books, as it is founded within the common law, that is the case law. That is not all about the law, rather what matters most about the law is the reality at hand, the context, the situation in which that law is applicable. That is what matters most. And Professor Holmes is the best teacher on this. Professor Holmes is seeking to help us understand that in this development of the study and the understanding of the realist jurisprudence, it is not the question of logic that matters to the understanding of law. What matters is the experience of the judge, because at the end of the day, law enforcement, law interpretation is the mandate of the judicial authority. And it is the judge to commit himself or herself in the interpretation as an individual or as a group in quorum. But what would determine the quality of the judgment or the decision of the determination or the opinion of the court is not the logic. Rather, it is the experience. This is what defines the legal realism to us. Under our section 23.4, the development of realism school of jurisprudence is seen in the matter of the reality of law, the reality of justice, and the reality of rights. This is what brings into our understanding what the legal realism from America stands to defend, that law as presented to us by the common law traditions, by the legal positivists, is ambiguous. Law is not clear. In that case, law must go through the interpretation in order for the law to meet the threshold of the legal realism. It must apply to realities. Those realities vary, they are diverse, and they keep on changing. They are not uniform. So it is not easy to look at law from the sociological school of thought or from the scientific perspective or the positivist perspective, which puts the law to be rigid, to be applied as it is, and to conform to the texture of the law. It must undergo the interpretation by the judge. The judge is a natural person with experience, with his background, historical background, cultural background, religious background, as well as economical background, social background, among other things we can consider. And those backgrounds also shall have influence or impact on the verdict, on the quality of the decision or the determinations of the court. This is the main argument by the realist school of thought. In this case, under our section 23.4.2, law is never about the logic, but about the experience. This is from Oliver Wendell Jr. In this case, we see under our section 23.4.3, law is the activities that advocates and honorable judges carry out before the floor of the court. It is the activities in the court, the litigations, the arguments, the disputes, but also this brings in itself a certain experience, which of course shall give more value to the interpretation by the individual judges, but also judges in quorum. This actually is what translates into the majority decision as opposed to the minority decision, the dissenting opinion of judges as minority, in which the dissenting opinion matters because this is the freedom of expression, which of course is attributed to the work of Oliver Wendell Holmes Jr., as a judge of the Supreme Court in the United States of America, and his great dissent is what has informed this reading of the legal realism and the judicial realism in practice, as opposed to the judicial activism. Judicial realism is all about the consideration, quote unquote, of the law and its application and applicability in a given context, a context which can be political, can be economic, can be social, can be cultural, can be religious, can be environmental. All this put together brings us to the best understanding of the American legal realism and its making and the influence it has in English common law jurisdictions, even here in Kenya, while the judges make decisions, and those decisions become binding because they come from the concept of stare decisis, in which it means that judges stand by their decision. They stand by the previous decisions that other honorable judges had come up with. While making their own decisions, they take into account those rulings. And those rulings, in that case, become precedents. They become the judgment law. That means they bind the decisions made by the honorable judges. That is what brings us to the judicial continuity and the systematic application of the judgments while coming up with interpretations. That is actually what we refer to as the case law. However, we move on rapidly here to see that this school of thought under our section 23.4.4, law is determined by the interpretation as well as the determination of the honorable courts. It is from this perspective we can read here under our section 23.4.5 that law is more of experience in terms of politics, but also more of the freedom, the right to freedom of expression. Judges making decision in freedom is very crucial for the legal realists, because in that sense, the judge is going to rely on his or her own experience to come up with the truth of the decision. And this is how the law, justice, and rights are seen in context under the realist jurisprudence. Let us again agree that in this understanding, under our section 23.4.6, the common law traditions is ambiguous according to the realist school of thought, in the sense that the positivist law as it is, but also the English common law that comes up with the law of precedents, the case law, makes the law unclear, ambiguous, and that subjects the law to the interpretation of the judge. So the judge has got that power and authority as judicial officer to interpret the law looking at his or her experience as individual, but also as a quorum. In this case, we see under section 23.4.6 that common law being ambiguous, the law is not clear and is never clear. That moves us to the important role and function of the judicial authority. The judge, the figure of the judge in making decisions takes into account the judge as a natural person and his decisions being also influenced by his or her individual experience, his backgrounds, as we have said before. Under section 23.5, we look at the nature of realism. What is realism? Realism is in contraposition with the positivism. Positivism is strictly and purely objectivism, scientific formalism, that everything must go according to the letter of the law. Everything must be interpreted as it is, and judges, by doing so, should come up with uniform and shared decisions. That is the position of the legal positivists. Legal realists instead disagree with this and see law as ambiguous, see law as not having commonly shared answer to the same problems, the same laws, the same evidence, and the same facts that are before the court. This puts the realist thinkers into the context of the reality. Law must correspond with the reality that is outstanding in the particular society within that particular jurisdiction. And that means that the application of the law to different circumstances shall take into account the context, the reality, and the principles. And the judge must use his or her experience and wisdom, or the lack of it, to come up with the ruling, the verdict, or the sentencing, or the holding of the court. This is very important and very crucial for our study of jurisprudence. Under section 23.5.2, we see also that apart from law is what is practical, what is real, and what is applicable within a context, we look at the law interpretation as very crucial, because law interpretation can supersede what is the substantive law, what is the substantive area of facts and evidence and all the procedural laws, and come up with a ruling that may depart from all this in order to emphasize on the wisdom of the court, backed by the experience of the honorable and competent judges. Professor Dean Pounds refers to this as law as social engineering. Law determines the outcome of the society. The functionalism thinkers, or those who see the functionality of law, would always see that the quality of law or the type of law would determine the quality of the society and the type of the society in size and shapes. But however, Dean Pounds, looking at law as social engineering in tandem with the American realist thinkers, is seeking to enable us understand one important truth, that the truth of law is not that of pure positivism, but that of the pure realism, in which law must apply itself to the phenomenon, to the reality at hand. And that is what determines the outcome of the decision of the court, and such decisions made by judges in the case law as in the records is what tells about the realist jurisprudence, that is the legal realism, as opposed to the legal positivism. Under our section 23.6, we see that law, justice, and politics are intertwined, in the sense that law determines the politics determine the law, whereas justice is also determined by all this stuff here. That is the law, rights, and politics. So we move to look at what is considered the freedom of the judge, that in principle, the judge can depart from the majority opinion and form the dissenting opinion. And Professor Oliver Wendell Holmes of the United States of America, in his great dissenting, has explained to us the context in which the freedom of expression works out well and speaks to the realist school of thought, in which the judge must be himself or herself while making his or her own considered opinion, whether in the majority opinion or whether in the minority or dissenting opinion. Under section 23.7, we see that alongside the American legal realism, there's also Scandinavian legal realism. The Scandinavian legal realism is more or less attached to the influence of politics, but also the influence of ethics, as well as the psychology in the working of law and justice in a given jurisdiction, looking at the quality and the nature of the legislation, taking into account that the lawmakers, the legislators, are politicians who are also influenced by other things apart from what would be considered justice. They are influenced, for instance, by the power, by money, by the economy, also by dynamics in different given societies, communities, and also the influences from other horizons that must take into account also some moral principles, also political principles, which may actually determine the outcome of what we are talking about. Our learning outcome here, already you can tell the distinction between the realist and the positivist legal thoughts and how they have influenced and determined our understanding today of the courts and how courts arrive at certain conclusions. But also another learning outcome here is that the realist school of thought has opposed the legal positivist school of thought, in which they have pumped in a very important concept that we cannot dismiss: the phenomenology of law. Law is attached to experience as opposed to law attached to logic. And that, again, is good for legal researchers, but also the students of law and the practitioners equally, while coming up with the predictions of the outcome of the court of a certain given hard case or maybe a very complicated matter before the court. Thank you for watching, and bye for now.